The argument is pretty simple. First of all, it's completely hearsay that there has been a doctor that I have refused to see. I have spoken with the doctor directly and explained very clearly that you don't give medicine to a child who is not ill, correct? We would all agree with that, I think.
I'm having trouble. Mr. Murphy, we sent a doctor to come and see you. You didn't even acknowledge that they are really there. They provided a medication. You are refusing to take it. I am not sure how
She's
I'm
gonna
going to be
get
persuaded that you're going to follow through when you're in the community. This is not the way that we show that we're engaged in taking care of our services when we're refusing to cooperate even inside of the jail. So I am concerned about how we're going to get into a groove and a plan for you to be in the community if I can't even get you to really engage while you're inside of the jail. So Ms. Lowry?
Your Honor, yes. Mr. Murphy, there's some side effects related to the medications, and
But he wasn't even meeting with the doctor. He wouldn't even acknowledge the doctor is there. I mean, it is so hard for me to get a doctor to go visit with the people in the jail. I have a high expectation that the doctors are going to be consistent. They're going to listen to you. They're going to work with you. Wow, when I asked the doctor to go out there and you're not even acknowledging that they're there, that is the exact opposite of my hope, because you're making the argument for why the doctors really shouldn't even be supporting the people that are on this docket, because they're going to show up and it doesn't make a bit of difference anyway. I mean, that is really the opposite of what I would ask from you in how you're engaging with a professional that I've asked to come out to meet with you. Ms. Lowry?
Your Honor, so the named victim in the case and my client's mother are present in the courtroom behind the prosecutor. You met them the last time. We sat over today because you lifted the protection order to allow Blaine to talk to Ellen Murphy over the phone, but she couldn't co-sign his PR bond and he couldn't reside in her house. He actually, I've learned he actually has his own apartment. So he wouldn't need to go back to Ellen Murphy's home where this sort of incident took place. And he believes that situation really was quite aggravated. And he would do better living separately as he was doing. His girlfriend is present in the courtroom too. She was brought up last time. She's a good influence. He's been willing to see doctors and take medications with her support before. And so he may keep an open mind about that, but she is also just good support for him. His request today, Your Honor, is that the court modify from a co-PR to a straight PR bond. Consider lifting the protection order just because that's their request and they are the named parties. But my client does not wish to return to that residence if the court approves this release.
Prosecution.
Your Honor, we discussed this last time. I expressed my reservations given the history of violence in the household of a full lift, no contact orders. I concur with everything that the court said and do not feel comfortable with a bond modification at this time. Should he get stabilized on medication, should we see a good release plan, I'd feel differently.
I'm going to deny the request today for bond modification. Make no mistake of it. I will modify a bond, Mr. Murphy, but bond is for me to know that you're going to show up to court and that you're safe in the community and not going to pick up any new offenses. I have to rely on the people that are in front of me when I'm looking at you, that you're going to work with the Bridges team, you're going to work with your lawyer, you're going to work with the people who are trying to help you maintain stability. I can't even get you to a baseline point while you're in custody. I don't have any faith that you're going to do that work with me when you get out of the jail. I don't have any relationship with you, but the things that you're teaching me about you as we're seeing each other in court fleeting moments during like any given few weeks. So I put myself in the shoes of your parents and your loved ones. They do not want to see you in custody. I do not blame them. But you all are in a Groundhog Day because you're doing the same things over and over, and there's a pattern here. We need stability. We need buy-in that he is going to follow through with treatment. And then if he's doing that consistently, I think living in his own apartment and being in the community and maintaining that sounds more promising. But this way is not persuasive to me that we're going to be getting anything done with Mr. Murphy if we can't even do it while he's in jail. Most people are pretty motivated in jail to do the things they need to do to try to get out. Can't bite on this at this point in time. This request is denied. Ms. Lowry, I need to bring this,
May I speak on behalf of myself?
it's really between you and your lawyer because everything's being recorded and can be used against
On
you.
behalf of myself. So the argument is pretty simple. First of all, it's completely hearsay that there has been a doctor that I have refused to see. I have spoken with the doctor directly and explained very clearly that you don't give medicine to a child who is not ill, correct? We would all agree with that, I think. Okay, so I am not ill myself, right? So I'm not going to subject myself to taking medication that will not benefit me at all. I am being held on no charges. I have not pled guilty or non-guilty or no contest or an NRI, and I have not been arraigned. This court system is very shaky, Your Honor.
The problem is, Mr. Murphy, that you have been advised and you are being held on charges. So you have
False
accusations.
charges is what I said.
Well, these are the charges and one of them is a felony, sir. And so
Hey, where did that come from?
that's,
Or what was the felony?
so I'm gonna let your lawyer go over that with you. But these are the things that are concerning and that,
Just made up. They're just made up charges.
okay, well, you are,
Well, you're condescending for no reason.
okay, so once you are well enough to enter a not guilty
That's safe.
plea, you might be 6 months away from trying your case. So understood, but I need you in a place, if we can get you in the community, that would be great. But you are charged. This process takes time. Your cooperation might make this go faster for you. But you will decide how you want to conduct yourself, and I am here to respond to whatever you choose. I'm sending you help, I'm sending you options, what you choose to do, but you are not a child, and you are being,
That I was.
and a doctor is explaining that there is a benefit to medication for you.
No, they haven't.
Yes, they have. They've prescribed it. So this is the issue.
That's
Ms.
hearsay.
Lowry, I will reset this matter to come in for review.
When's my arraignment?
You have already been advised and arraigned of your charges. Your attorney can go over that with you again. Court will set this matter over to the 30th of October at 1:30 in the afternoon. People are on notice. We might be addressing bond. I will rise to the occasion if you have a change of heart.
I won't.